I'd like to start this video off by apologizing. I am so incredibly sorry that I did not get this information to you sooner. Oh my gosh! Hi, I'm Mikayla and I am a civil lawyer. Did you know that as you're sitting here watching this video right now, you're probably missing out on money from a class action lawsuit you're a plaintiff in, but don't even know you're a plaintiff in? Yeah. It sounds crazy, and that's because it is. I only found out about this a few years ago, and today I'll be teaching you all about the class action lawsuits you're missing out on, along with a ton of other civil legal terms that you and everyone else need to know. I've also posted a basic terms video and a general terms video, so be sure to watch those if you haven't already, and let's get into it. Demand. Demands to me are so cool because they can result in a case resolving before you even formally initiate a lawsuit. And a demand is exactly what it sounds like. It is a forceful request that a party in a dispute do something. It comes in the form of a letter usually written by a lawyer on their client's behalf. If you get into a car accident, for example, before you sue the at-fault party or their insurance company, you can have your lawyer send them a demand letter, which basically outlines everything you are demanding to make this case disappear. They don't always result in a resolution, and sometimes parties don't even respond because they're not legally obligated to, and you end up having to sue them anyway. But sometimes it results in an agreement that prevents you from having to waste a bunch of time and money on the formal legal process. And who doesn't love saving time and money? Complaint. If you do have to formally initiate the legal process, however, that starts with filing a complaint. A complaint is, again, exactly what it sounds like. It's a document setting out the facts of whatever incident you're claiming caused you harm and the legal standing you have in order to support the claims you're making. Complaints also detail all of the injuries you've received as a result of the harm that was caused to you. It's the birth of a lawsuit, so to speak. Answer. An answer is the opposing party's written response to your complaint. It lays out which statements you've made that the defense disagrees with and will contest. And an answer is often accompanied by a list of affirmative defenses, bonus term, which is a legal argument that, if proven, will defeat your claim. Statute of Limitations. One thing you must prioritize as a plaintiff or the person bringing a lawsuit is the time period in which you have to bring your claim. Most claims have a statute of limitations, or an SOL, which is a specific time period you have to bring your claim. And if you don't, your claim is forever barred. The SOL typically begins when an injury occurs or when it's discovered that an injury occurred, and it varies state by state. There are also some crimes that don't have an SOL, typically crimes that result in the death of a person. But again, this varies state by state, so check your local laws. And one action where the statute of limitations will never run is you subscribing to my channel. So if you haven't already, just had to throw that in there. Contract. Most people know that a contract is an agreement between multiple parties that results in a legal and enforceable obligation between them. But what I found a lot of people don't know is just how easy a contract is to form. There are several different intricate elements that go into forming a legally binding contract that I'm not going to go into in this video. But just know that a contract doesn't have to be a formal, long document drawn up by a contract lawyer. At the most basic level, all parties to a contract must be aware that a contract is being formed and have a mutual understanding of what that contract is about. There have been contracts written on napkins in sketchy business meetings that end up being enforceable. You can even form a verbal contract with someone without even writing anything down, though, as I'm sure you can imagine, they are a lot more difficult to enforce. Damages. When a plaintiff suffers harm, damages are what is needed to make that harmed plaintiff whole. This is often in the form of money, but it can come in other forms as well. For a case to be successful, oftentimes, even if a person has done the most heinous thing to you, you need tangible damages that are legally recognized by the court. Otherwise, instead of going to court to seek money, you can seek nominal damages, which equate to $1. You seek nominal damages if you sue someone for the sole purpose of affirming that your rights were violated. Basically, if you just want it to be known that someone caused you harm, even if you didn't really suffer any big damages from it, you get nominal damages. And those rights are affirmed with a single dollar. Waste of time? It depends on who you ask, but just know that if you're just trying to make a point, that route is there for you. Loss of consortium. Consortium is the benefit of affection, companionship, or assistance that one is entitled to receive from their spouse, parent, or even sibling in some cases. And if your family member is harmed and you have one of the aforementioned relationships with them, you too can bring a personal injury claim alongside theirs for loss of consortium. An example may be, you injured my husband in a car crash and now he can't help out as much with the kids, or it's negatively affected the intimacy in our relationship. It's a claim I don't think a lot of people know about, but should. Defamation. Defamation is a term that is constantly being thrown around, especially by celebrities. People often think that just lying on someone's name is defaming them. And while that's not exactly false, there are a lot more elements that go into bringing a formal defamation claim. Defamation can be written or spoken, and if it's spoken, it's called slander. And to bring a formal defamation claim, someone must have done all of the following. 1, they must have published a false statement about you. It doesn't count if they just gossiped with their friend at a coffee shop. 2, that statement must have been about you and published to a third party. If someone comes up to you and starts saying a bunch of false statements to you, they have not published those statements to a third party. 3, and something a lot of people seem to miss, is that false statement must have caused you actual injury. If thousands of people are tweeting false statements about you on Twitter, but you didn't receive any actual consequences other than your feelings being hurt, sorry, babe, there's really not much you can do about that legally. That's really all you need for a defamatory statement, but I'll leave you with number 4, reiterating that that statement must be false. And this is something I like to tell everyone. The best defense to a defamation claim is the truth. You can go around saying the most atrocious, disgusting things about someone, but if what you're saying is the truth, you haven't defamed them. Settle or settlement. You've heard me throw around the word resolution or resolving a case a lot in this video, but the legal term for that is settling. A settlement is a resolution of a legal dispute without the use of trial. You can settle a case before you initiate a lawsuit, which is called a pre-suit settlement, or you can settle a case after the initiation of a lawsuit, but before the trial begins. On average, only 2% of cases, both criminal and civil, actually make it to trial. The other 90% often resolve in another way, typically a settlement in the civil world. Class action. Finally, what we've all been waiting for. If you're going to take one thing away from this video, make it this. A class action lawsuit is a lawsuit brought by one or more people that represent a larger group of people called a class. When a class of people are harmed by a product or company, for example, that class can sue the person or company responsible and obtain one lump sum of money for damages. Those damages are then split among all of the people in that class, the people who were harmed. So what does this have to do with you? You may have heard of the more popular class action lawsuits, such as the $206 billion tobacco settlement in 1998, or the $20 billion BP Gulf of Mexico oil spill settlement in 2016. But there are dozens of smaller class action lawsuits that happen every single year that you've probably been affected by and have never even heard of. An example being the $181 million overcharged for chicken class action settlement that happened just last year in 2022, where if you purchased any fresh or frozen raw chicken products since 2009, you're part of the class that's been awarded damages. I've applied to several of these class action lawsuits in the past, and while typically the money you receive isn't very much, it's really nice to get a paycheck in the mail or a random PayPal deposit from a class action lawsuit you forgot you applied to. In 2022, I got 2 PayPal deposits from class action lawsuits that I was a member of, one of those being a TikTok data breach. And in 2021, I got 1 PayPal deposit and 1 check in the mail, one of those being from a Fashion Nova class action. I mean, you can't really beat taking 5 minutes to fill out a form and then getting a random sum of money for it later. I'm going to leave some of the websites down below in the description box that I regularly check to see about the new class action settlements that I might qualify for. And if you ever think that you just might even qualify for one, always, always, always apply. I hope you guys got value out of this video and are subscribed to my channel, because next week I'll be posting the criminal version of this video and you're not gonna wanna miss it. And before you go, be sure to click on the video on the screen right now for my new series, Real Lawyer Ranks, where I rank some of the dumbest laws in Alabama. Thank you guys so much for watching this video, and I'll see you in my next one. Goodbye and go thrive.